Welcome, I'm Brendon Christian, Director at Christian the Law Firm, and in this clip we're looking at ways, i.e. attempts that could be made pre-litigation to resolve a potential dispute amicably. Please note, if you are presently involved in a dispute that is before the courts, i.e. full-on litigation, please do take specialist legal advice around the circumstances pertaining to your particular dispute. This clip is focused purely on attempts that can be made to resolve a dispute amicably pre-litigation. Now, to get to it, when faced with the choice, in our experience, most businesses would choose to avoid litigation, and there are genuine reasons for that. First, going to court is an incredibly expensive exercise from a purely financial perspective and more. Secondly, it's incredibly time consuming. It could take weeks, several months, at times even years, to resolve a dispute. And that's a lot of staff time taken out of the office to attend court, give evidence, and so forth and so forth. And of course, if the entire process is not properly managed, it could be an incredibly stressful exercise as well, going to court, that is. And so it's with those important considerations that businesses, more often than not in our view, are committed to an amicable resolution, i.e. settlement, of the dispute pre-litigation. And so it's with that thinking in mind, we thought we'd put together this clip. And so the idea behind this clip was simply to offer possible ways or possible suggestions and possible attempts that could be made to resolve a dispute amicably pre-litigation. The first important observation that we would offer is please do communicate. If a letter comes in, please respond to the letter. If an email comes in, please respond to the email. Similarly, if you get a telephone call or a request for a meeting to discuss the potential problem, please respond to those requests. The worst thing that a business could do is to try and ignore the problem or avoid the problem or pretend that the problem does not exist. That's the absolute worst approach that could be taken. The proverbial ostrich with its head in the sand type mentality has no place here. It is not the way to go about things, and it will not assist at any level to try and avoid the problem. So we say reach out and communicate. So you're concerned around the implications of that. Well, the first thing you can do is make clear to the other party that a potential meeting will be purely without prejudice. Head up, if you're responding in writing, head up any letter or any email without prejudice. Even on a telephone call, before you say something of substance, say to the other party at the other end of the line that this is purely without prejudice. So do communicate. The other important question is, do we communicate only in writing, or do we communicate orally, or is it both? That will depend on the circumstances of your particular case. Do please take specialist legal advice. We say it's always good to put your position in writing so that there is a written record of the attempts you made and the offers, if indeed there are any offers, you're putting on the table to try and resolve the dispute amicably. In certain jurisdictions as well, certain courts would have pre-action protocols that they would require either or both parties to follow before approaching the courts for assistance. And so it's with that in mind as well that it's always good to put your position in writing. Please also note the importance of time limits. Time limits do come into play here. So if the party says that please respond within 7 days, try and respect that. If the party says respond within 14 days, try and respect that. And if you cannot respond within the suggested time frames, it's always good to send out a holding letter or a holding email to the other party saying why it is you cannot respond within that particular time frame, but that you endeavour to do so. There's also certain time frames as far as the courts are concerned with respects to issuing a claim within a certain number of months or years. Again, please do take specialist legal advice around the time frames that are in play, particularly if you're acting as the plaintiff or the claimant. The other important point to note is that if indeed and in fact there is a genuine commitment on both sides to settle, it has important implications. I've often heard clients say in consultation, Brendon, the other party is a valuable client, and so I really don't want to lose that business relationship going forward. And that's why I'd like to try and settle this, because I want to keep this client going forward, as it were. So those are important business considerations to take into consideration. If there is a settlement, it's always nice to try and reduce it to writing. Here I have in mind a settlement agreement or a settlement letter. The beauty of that is that it records in full and final settlement exactly what the parties have agreed to by way of resolving the particular dispute. And so, again, do take specialist legal advice on that, because there are certain clauses within the settlement agreement or certain terms, as it were, that must form part of the boilerplate template of the settlement agreement. So in summation, it is important, the first point, it is important to communicate, orally or in writing or both. Do reach out, we say. Mark up communications without prejudice. Secondly, note time limits. Time limits are in play, particularly where you need to respond to a particular letter and so forth. And of course the court has its own time limits in mind as well, i.e. when a particular dispute will lapse, i.e. expire. And then thirdly, if agreement is reached, it's always good to reduce it to writing, a settlement agreement or a settlement letter. I am Brendon Christian, Director at Christian the Law Firm. Please do take specialist legal advice around the circumstances pertaining to your particular dispute, be it pre-litigation or during litigation. It's imperative that you do. And in so doing, if you need our assistance, please do get in contact with us. We hope you enjoy this clip. It's Brendon Christian, Director at Christian the Law Firm. Thank you very much indeed.